their training and policies, you can only shoot someone if it's immediate a threat of death. Visibly empty hands, complying with a command. I mean, is that really where we've gotten? That we have to have a case that says if someone's complying with their commands and puts their hands up for 2 seconds, that you can't shoot them? I mean, we're in a bad spot.
Well, if it's any comfort, the Supreme Court has expressly said qualified immunity does not require a case directly on point. That's Ashcroft v. Alkit. So point's already in the books.
I get that. But the problem is we all know that there's very rare instances where there's a published opinion. Right? There's a lot of factors that go into that. Many cases aren't appealed. Many arguments are made and they're not published. And so if we have all these cases that say there has to be an immediate threat of death, if we have all these cases that say a weapon in someone's hand is not enough, if we have all these cases that say you should give a warning when feasible and only when there are no reasonable alternatives, how could we say that someone complying by putting their hands up for 2 seconds is not a constitutional violation?
I mean, to your point, I have seen this video many, many times as well, and I didn't count 2 seconds. But I think that goes to the point of what the district judge was pointing out, is that people can look at this video and draw different things from it, which suggests to me in some ways that there are triable questions, at least on the first prong. And so here's my question. Even if you don't get qualified immunity, would the state law claims continue to go forward on if there are genuine disputes of material fact in this case?
Yes. So if...
For negligence and Bain Act violations.
If this court decides there are disputed issues of fact on the first prong of the analysis, then those claims should proceed. But I would suggest even on the second prong of the analysis, and maybe this is a case where special interrogatories might be important, because I do agree that different people can view the evidence and that video in different ways. This court in Voss and other cases had said even a video is subject to more than one reasonable interpretation. Different people could see it differently. And so at a minimum, there should be some questions of factual findings, because I think hopefully you would agree, including yourself, Judge Donato, that if a jury decides that the officer perceived that his hands were visibly empty and he was not reaching for anything at the time he was shot, let's say that's a factual finding of the jury.
Well, the qualified immunity is for the judge.
I know that, but
it's not for the jury. We have to make that decision.
I totally agree with you, but it has to be based on certain factual findings. So what if the trier of fact in this case said that we find that the officer saw that his hands were up, saw that they were visibly empty, and perceived that he was not reaching for a weapon at the time of the shooting? Let's say that's the facts to assume. Then one would have to say the law was clearly established and this falls within the obvious. And I
just don't see this as being an obvious case at the least. As a general principle, we all understand the immediate threat that an officer has to face before using lethal force. But this is a unique one. You have someone that's initially reaching or seems to be reaching and then doesn't, and is complying, and the duration of time between compliance and not is in somewhat in question. This doesn't appear to me to be an obvious case as some of the other cases might seem, and Casella at least makes clear that the obvious case is a pretty rare one when you actually reach to a legal principle to find that it's obvious. Isn't that the case?
I guess different, good minds could differ on a point. I understand what you're all saying. From our perspective...
Well, not all of us.
Well, they are. Go ahead.
No, go ahead.
No, I'm sorry. I was just going to finish and I was going to open it up for any follow-up questions.
You can make your point.
I apologize. Maybe I'm going to let you, I'm going to open it up to any questions. I think that would be a smarter way for me to go.
I don't have any other questions. Thank you for your presentation.
Okay, so I'm just saying this in conclusion. Number one, I feel at a minimum, there are disputed issues of fact as to whether this was a constitutional violation, and therefore, at a minimum, the first prong of the analysis should be in plaintiff's favor. So as you pointed out, Judge, that then at least the state claims could proceed. And secondly, I strongly still feel, even though I know I'm getting some pushback from your honors, that the law was clearly established at the time that shooting a visibly unarmed man who's complying with the officer's command to put his hands up was a constitutional violation. Thank you.
Thank you.
I'm assuming there's no other questions?
No other questions, thank you.
Okay, thank you.
I can't let the constitutional violation go. Nowhere in the record does Xavier Lopez say that he never reached. He didn't reach once. He didn't reach twice. He reached 3 times. If you're gonna stop and look at that one frame still, look at all the frames from the beginning to the end. His hands came out of these pockets, and then there was nothing in his hands. And he goes to the lapel, pulled it out, reached. That was when the officer had the constitutional right, legal right to respond with deadly force. But the officer exercises extraordinary restraint. He puts his hand in there. Watch, where Xavier Lopez puts the arm in to grab something. Still doesn't shoot. Pulls the gun, and at this point, you can see Officer Wright's hands out. It looks like he touched him, was about ready to grab him. Keep frame by frame. Xavier Lopez puts up his arm to stop the officer. The officer went back and shot twice in succession. It was a constantly fluid motion. It's objectively provable factually from the video. He goes like this, not this, not this. This was not 1, 1,000, 2, 1,000. That was not in the video. It's blatantly contradicted by the video. He goes like this, turns his head, and his hands don't go up. They go here. The weapon is here. I don't know why we're getting around this. There was a gun. There was a gun. Everybody knows there was a gun. The officer knew it was a gun. The minute that he shot, he said there's a gun, not to warn Xavier Lopez. It was to warn the fellow officers that were approaching, and they kept him under legal cover. They didn't empty their magazines. They reassessed. They were still at danger.
So, counsel, what amount of time would it be prudent for an officer to wait then before when it would be inappropriate?
Well, they need at least 1.5 seconds to perceive and respond, but there has to be some sort of, at least a moment to analyze. There's a new piece of information, and that information was this and this. I'm not going to speculate what the officer would have done if he had enough time to take that information in. I'm just begging the court.
Well, would it be 3 seconds?
I beg your pardon?
Would it be 3 seconds?
No, in fact, my very skilled opposing counsel had that come up this month, where there was a body-worn camera and it was obstructed for 3 seconds, and he argued in 3 seconds, didn't have a gun, it had a baton, that the same arguments that he's making here in this court, the Ninth Circuit said no. There was qualified immunity. There were factual issues because the video was obstructed. We don't have that here. And I'd like to end.
To your view that the turning to the left, that rotation doesn't make this, or rather, it's reasonable because of the turning away, or because he's not raising his hands enough? I'm not sure I'm following your argument.
Certainly. We sit here when we treat as a fact that this was happening. He was standing still. The command was what? Don't move. Don't move, don't move, don't move. Officer Wright said it, and his colleagues said it. They were approaching him. Don't move. What does he do? He moves, and his hands drop. The gun had not gone off yet. When the gun goes off, his hands then drop further. Now, the shooting would have a play into some of that.
But that's in light of the prior non-compliance, too. I mean,
that's correct.
Yeah.
I started out with the body-worn camera opens the door to jurisdiction, and I wanted to finish to say the reach, the 3 reaches, closes the door of liability. In Riverside County, in the last 12 months, we've lost 4 officers. One of them was execution style. When a gun is pointing at an officer, the body-worn only captures that. That officer did not survive. That's a very real situation, the facts on the ground for these highly skilled officers. 1, 1,000, 2, 1,000, you're asking them to have no human reaction time. The body-worn camera couldn't be clearer. And Officer Evan Wright, And in light of the fact that Xavier Lopez never once says he didn't reach, let alone 3 times, they never once said he was compliant. What they talk about is his intimacy with the gun. He didn't have it completely in his hands. It's irrelevant. And this court has rightfully said Cruz is the controlling case. And your retired honorable colleague, Judge Kaczynski, said, specifically in there, I cited it in my brief, if the jury is to find any reach, it's not the qualified immunity argument that stops. It's the constitutional inquiry. The officer had the legal authority to respond with deadly force. The stakes could not be higher. The consequences could not be dire. If this court says to these officers, these fine men and women that are dealing with the facts on the ground that are dangerous, that when a dangerous, known felon with a potential hostage situation in the front of him and a getaway car in the back, both of which with 9 days earlier, he approached terrorizing one and almost putting the community and officer's life at risk in the getaway. That officer is not authorized to use force. That's not this law. Thank you.
Thank you. Thank you both for your helpful arguments. The matter will stand submitted.